Today, we're looking at potential mistakes that can lead to a very severe sanction by the Immigration and the Home Office. We're looking at misrepresentation, false representation, production of false document, and deception. These areas of law are very, very complex and usually will lead to a potential refusal, sometimes without a right of appeal, other times with a right of administrative review, and most times with a right for judicial review. However, there are serious allegations which can impact future applications. My advice today is to ensure that you understand exactly what you're applying for and the evidence you're providing in support of your application. The Home Office has categorized all these areas into four broad areas. The most serious one is deception. The courts have said that if the Home Office refuses your application under deception, there must always be an intention to deceive. So the Home Office cannot refuse an application under the deception route, which normally comes under Part 9 of the Immigration Rules, which will be paragraph 9.8.1 or paragraph 9.7.1, which covers the discretionary refusals. It's always important that where an allegation of deception is made, you challenge that allegation. But I must advise you that if the allegation is proven, then the burden falls on you to discharge the burden on the standard of proof of reasonable probabilities that indeed whatever allegation has been made is not true. The allegation about deception will always have an element of intent to deceive. So the Home Office will have to show that you had an intention to deceive. Usually will be things like production of false document, either a false passport or using a false instrument, sometimes providing school certificate, English certificate, university certificate. And most times it's bank statements which have been used, which you know that you do not have a bank statement or bank account with that bank. And sometimes people genuinely have a bank account with that bank, but they have either padded the account balance or inflated the balances. All this will amount to deception because you obviously had knowledge to deceive the Secretary of State. I must also advise everyone that it's not always that the action has to be your action. So for example, if an agent is representing you and the agent produced a false document, which would be a passport, a bank statement, a birth certificate, a death certificate, any other document or information that was meant to deceive the Secretary of State, that action by the agent or the lawyer will be construed as your action. There is no obvious channel of challenge in that case. The only way you can challenge it by way of judicial review. There are either minor mistakes that also can lead to discretionary refusals. And I use the word discretionary refusal because it means that the Secretary of State may or may not refuse you. Very simple things like providing false information. For example, if you're asked that have you come to the UK before and you didn't think anything about it, because most people think that when you're asked that question, it's only when you have genuinely come here that you have to declare. But even if you came here in a false name and you've gone to change your name, it's always important to declare. If you've used a name before and you've now changed that name, you must declare. If you've changed your date of birth, always declare. If you have previously overstayed in the UK and there's evidence of that, always declare. If you've made an application before, whether granted or refused, you must always declare. Even if the application is not to the UK, but to any of the European countries or North American countries, always declare because the Home Office has a way of knowing. If any of the information or documents that you've provided leads to a refusal and an allegation of a false document being used, you will always have the benefit of seeing what evidence the Home Office has. If they don't provide what we call the DVR or the document verification report, you can request for it. I always request for the document verification report, because in their own guidance, it says that where they rely on a document, that has to be disclosed. And it's only fair that where a matter as serious as deception is alleged against you, then you should be given the benefit of challenging that particular matter. So the first thing to do is that if the allegation is made, ask them to provide the evidence. The second thing is that if the allegation is made through a government agency, ask them to also provide the evidence. If the allegation is about providing a false instrument or a false document, ask for the document verification report. If the allegation is that something that you've said is untrue, ask them to prove it. Because the allegation means that they have to discharge that burden first before you discharge your burden of proving that it's true. So they cannot just make a bare allegation that we believe that what you've said is wrong or is untrue. You will have to ask them to prove it. But to avoid all these mistakes, these are the 5 things I will ask you to do. 1, your application is your application. Whether it's made through an agent or a lawyer, the actions of those will be construed as your actions. So read the draft application before you submit it. 2, make sure that your passports are the true reflection of your identity, and ensure that every information in your passport is noted. For example, if a visa application has been refused before, there will be an indication of that in your passport. Check so that when the question is asked, you give the truthful answer. 3, your supporting document must always come from you. If you're providing a university certificate, an English certificate, a bank statement, this is your bank statement. So don't let an agent deceive you that they can create a certificate for you to meet the requirement. If you're found to have provided a false document or a document which is forged, then deception will be used against you and you'll be banned for 10 years. The other thing that I always ask you to do is to make sure that if you're not sure, you declare. If you've come to the Home Office before, you've made a previous application and you're not sure of the information you put in there, it's always important to make a subject access request, SAR. If you go on the Home Office website and you say SAR or subject access request, it will give you a form to complete. It's a very straightforward form. Request for all your electronic and paper documents with the Home Office, and they will email it to you. I hope this is helpful to someone, but we are finding a lot of this in our community, and this video is to help people avoid such unavoidable mistakes, which can be disastrous and may ban you from coming to the UK. If you like this video, please follow us, like our videos. But if you want further advice, please do not hesitate to contact us on the numbers above. I will also share this video on our website where you can go through.